All right, back again. Yeah, I'm just finished up the last saving the last video, so I'm just gonna start from the front and see if I can't meet them in the middle here. So starting at question one now. Explain the ESA's jeopardy and consultation provisions, section 7. Why are these provisions so significant to understanding the decision making decision making pertaining to federal public lands? Please be sure to use an example in your answer. So, Section 782 requires agencies to ensure that any action they authorize, fund, or carry out is not likely to jeopardize the continued existence of a species or result in the destruction or adverse modification of a habitat of such species. Additionally, requires that action agency that's authorizing funding or carrying out an activity to consult with the Fish and Wildlife Service or NOAA, depending on where they're at or where they're acting, on how to avoid jeopardy or adverse modification of that habitat. Let's see, okay. So that's kind of that jeopardy and consultation provision there in Section 7, that ensuring not to jeopardize continued existence and adverse modification or destruction of habitat as well, and then consulting with those administering agencies, the Fish and Wildlife Service and NOAA, in order to on how to avoid such jeopardy or adverse modification and destruction of habitat. Please be sure to use an example in your answer. So, I guess like TVA versus Hill. Now, granted, this one I guess doesn't really pertain as much with the consultation provision, but that U.S. You see that going back, the University of Tennessee law student Hiram Hill challenges the TVA dam on the Little Tennessee River. Funding for that dam had been approved in 1966. Work began in 1968. NEPA 1970 halted the dam. Dam continued work again in 1973 after the completion of the EIS. Then 1973 the snail darter is also discovered in the river and then is promptly listed as endangered upstream of the dam. 1975. And that Little Tennessee River, following that designation, is designated as critical habitat for the snail darter. And then Hill, that litigant, argued that the damming of the river would destroy that critical habitat and would be a direct violation of that Section 7 jeopardy provision. And the TVA came back and argued that that $80 million had already been spent and that continued funding had already been approved. However, the court ruled in favor of the snail darter, and in Hill's argument, and and they enjoined the completion of the dam, and this will display that that teeth of Section 7, its substantive nature of that jeopardy provision as well. And I guess I could that consultation an example of that just how that's been applied. I don't. Oh yeah, I got it here. So there was the Southwest Center for Biological Diversity versus the Bureau of Reclamation. So the Bureau of Reclamation, in charge of the the Hoover Dam in Lake Mead. We're going to be doing some activities that would cause that lake to increase or go up. So they had conducted an initial biological assessment. I think I'm kind of going into the next question, but anyway. They had consulted with the Fish and Wildlife Service, initially and then formally after conducting their own biological assessment, and essentially, this they'd been issued some. Like I said, this is kind of out of the bounds of this question, but they had consulted with that federal agency, before they when considering the effects of their actions, and it was what the agency came back with. It was challenged, but they were ruled in favor of. What is a biological opinion in the context of the ESA? Describe a real or hypothetical example of how a biological opinion could impact a proposal or decision by the U.S. Forest Service, Bureau of Land Management, or National Park Service. Be sure to reference an incidental take statement / permit and reasonable and prudent alternatives somewhere in your response. Biological opinion. So I guess I'll just kind of start at the beginning of the consultation, section 7 requirement. But an action agency kind of first starts off by first things first is they will contact the Fish and Wildlife Service or NOAA, and just to inquire if there's any listed species in the area that they're considering an action. And so they contact the proper administering agency and say they find out that there are some listed species present. They will then conduct a biological assessment or an informal consultation, which is just this is just among themselves. And they'll conduct this biological assessment to determine if the listed species present will be affected by the action. And if they determine in their biological assessment that the listed species will be affected by the action, then they must do a formal consultation with the Fish and Wildlife Service or NOAA, and this is when the Fish and Wildlife Service or NOAA conducts their biological opinion. And essentially, in their biological opinion, the Fish and Wildlife Service or NOAA, the administering agency, is essentially just determining or deciding whether the action is likely to jeopardize the continued existence of the species or result in adverse modification or destruction of the habitat. So this is really looking, is that going to jeopardize that continued existence? And then, following this biological opinion, if they find that it is going to jeopardize that continued existence of the listed species or result in that adverse modification, the Fish and Wildlife Service is going to suggest some reasonable and prudent alternatives, RPAs, which are some measures to minimize and mitigate in order to change just some changes to that action, or additional actions, as we see in this case here, that to avoid jeopardy or habitat modification or destruction. Or additionally, the Fish and Wildlife Service, after conducting their biological opinion, may also just they find that the action is going to result in an incidental taking, or could result in an incidental taking, I should say. The Fish and Wildlife Service can issue a incidental take statement with its biological opinion. So that maybe they don't find that that the action is going to result in jeopardy or modification of habitat. They might, but there's still a chance that some of these listed species may get caught in the crossfire and be taken incidentally. They'll give out this incidental take statement, which essentially, the incidental take statement, as seen down here, is a written statement that specifies the impact of such an incidental taking of species, specifies the reasonable and prudent measures that their secretary considers necessary or appropriate to minimize such impact, and then sets forth the terms and conditions that must be complied with by the federal agency or applicant to implement the measures specified here. But it essentially lays out, I don't know. I'm feeling, I'm kind of out of it here today. I'm missing some pep or something. But additionally, after conducting that biological opinion, and say they come back and it's they do find that the action as is going to result in destruction of habitat or jeopardy and jeopardy of species. Maybe they list off some strong, reasonable, and prudent alternatives. It's an unfavorable biological opinion. They're raising some big red flags about what could what could occur from if this action is to be continued as is. The Fish and Wildlife Service and NOAA, they can't halt an agency action directly. However, if an agency, if this biological opinion, a very unfavorable BO is given to an agency over an action, and that agency ignores it and continues on full ahead, it's going to be very open to litigation and likely result in an arbitrary and capricious ruling and an enjoyment of the action from the courts. So going to an example here of these of kind of how this process plays out. But so yeah, I talked about it a little bit in the last question. But the Bureau of Reclamation, was conducting activities on Lake Mead, at Hoover Dam, lower Colorado River below the dam, and it was going to result in the lake level, I think, increasing in this scenario. It was going to go up, and it was going to potentially, take out this endangered flycatcher bird habitat. They require these riparian areas with riparian trees for their habitat. So they initially conduct a biological assessment, and they conclude that yes, there's going to be some potential takings. So they then formally consult with the Fish and Wildlife Service, and the Fish and Wildlife Service comes back with a biological opinion that provided some reasonable and prudent alternatives, and also issued an incidental take statement to the but that and these RPAs and incidental take statement require that the Bureau of Reclamation to procure and protect 1,400 acres of unprotected riparian area elsewhere. So maybe not along the lake, but protected unprotected area elsewhere, and then also provide some additional on and off-site compensation for historical flycatcher habitat, as well as continued development of a multi-species conservation program, and that incidental take statement allowed for an unquantifiable take of that flycatcher at the Lake Mead Delta. But yeah, so yeah, in your reasonable and prudent alternatives in this case, it required them to procure and protect that 1,400 acres of unprotected riparian area to compensate for the the potential riparian habitat that was going to be destroyed by the agency action. And like I said, I think these RPAs were challenged by this Southwest Center for Biological Diversity, but it was held up. These was held up by the court in their ruling. And yeah, there's also, like I said, additional on and off-site compensation, and then a continued development for that multi-species program as well. So that was just kind of a small example of this process in order. Yeah, I'm trying to think if I could tie that into any of the other parts. What is the primary difference between listing and managing a species as endangered and threatened pursuant to the ESA? Be sure to discuss the issue of management flexibility in your response. I wonder if okay, I do. So an endangered species listing is essentially, a species that's in danger of extinction throughout all or a significant portion of its range. And so, this is the Section 9 takings clause, prohibition on takings clause, is directly applied to these endangered species. As a species is, when a species is designated as endangered, the Section 9 taking prohibition is automatically applied to it. Whereas the threatened species is defined as likely to become an endangered species in the foreseeable future. And the thing with the threatened species, even that threatened listing does not come with that Section 9 protection like the endangered listing. So when it comes to that agency discretion, is that that endangered species listing definitely places some more managerial discretion on those on decisions surrounding potentially that could potentially be affecting endangered species. That management flexibility is definitely reduced. Because they have to be more they have to be compliant with those Section 9 takings prohibitions, or definitely more aware of those Section 9 taking prohibitions when those endangered species are present. Is there anything else I got on here? I don't think so. No. Oh my God. Explain the ESA's. I feel like I'm saying that with every one of these questions, but man, explain the ESA's take provision. I don't know. I'm complaining. Explain the ESA's take provision and how it relates to harm, and thus land use and or water management. Be sure to make a connection between each. Be sure to discuss the ESA and ESA regulations pertaining to take in your response. Provide an example of an indirect take in your answer. Let's see, which one do I want to go to here? There we go. So the take provisions, Section 9, not just limited to federal actors, but any person is prohibited from taking an endangered species. And like I said, this can be extended to threatened species as well by the Secretary in Section 4D of the ESA. And then take, as described in statute, is described as, to harass, harm, pursue, hunt, shoot, wound, kill, trap, kill, capture, collect, or attempt to engage in any such conduct. And like a direct take is, it's directly, I don't know, like direct take would be me going out and shooting, say, what's an endangered species? Now I can think of one. If I were to go into Yellowstone and shoot a grizzly, that would be a direct take. Reducing wildlife to a possession by capturing or killing it, that's pretty straightforward there. And then so kind of addressing the indirect take, that's a little different. I think in the book, an indirect take, I can't remember the book examples, but in the in this case here, this would be an example of an indirect take. But in the Palila versus Hawaii Department of Natural Resources case, where Hawaii DNR introduced that these feral goats to the island for a hunting recreation opportunity. These goats go about and they start eating these mamane tree shoots and seedlings. And there's an endangered bird in Hawaii, Palila bird, which requires mature mamane trees for food and shelter. But the goats, by eating these shoots and seedlings, prevents these mamane trees from maturing, and is therefore destruction of potential future mamane habitat. And so the plaintiffs argue in this case then that by browsing, the goats were impairing that Palila habitat. So no direct harm to any current Palila birds, but harm to future Palila, or even harm to future Palila, result no trees for nesting in those future generations. The court in this case did side with it was the Sierra Club that was litigating on behalf of Palila, the Palila bird, and the courts side with them, stating that the mamane forests are essential for the Palila survival. The bird had evolved with the mamane trees over centuries and is uniquely adapted to feeding upon the mamane. The mamane trees provide food, shelter, and nest sites for the Palila. And they went on to include that the Fish and Wildlife Service regulations define take to include significant environmental modification or degradation as well. But so that is an example of an indirect. A kind of a longer example of an indirect take. I think I don't know. There were some other ones in the book that were a little more straightforward, I guess, of an indirect take, and I should just put one of them down on here. I'm trying to think of one. It's very it's I don't know if it would be an indirect take if you say you were to. I'll have to double check on that. Yeah, 'cause I don't want to say the wrong thing. And then, I guess following this case, the Fish and Wildlife Service did also promulgate a new regulation to defining harm, in the definition of take, to include act that actually kills or injures wildlife. Such act may include significant habitat modification or degradation where it actually kills or injures wildlife by significantly impairing essential behavioral patterns, including breeding, feeding, or sheltering. So it kind of reassures, goes along with the decision of this case, because and that new definition was also upheld in a very similar case immediately following this on Hawaii, Palila 2, where, like I said, very similar scenario, just instead of goats, it was feral sheep that were doing a very similar thing. But yeah, so yeah, that new definition, continue, backs up that harm could include significant, modification that may result in either actually killing or injuring wildlife by impairing those essential behavioral patterns. I might call it. I am just struggling here. So I'm gonna hang it up here. I'm actually pretty close to being meeting in the middle, but I'm yeah. All right. Yeah, I got at least one or two more of these I'll probably be doing. So